listener production.
In the early 1990s, Australia's media landscape was changing. Television programs and investigative journalism were probing the actions of politicians past and present, sometimes blurring the line between scrutiny and sensationalism. It was in this climate that David Lange, former Prime Minister of New Zealand, found himself unexpectedly at the centre of an Australian legal storm. I'm Dan Mullins. This is Crime Insider's Judgment, a deep dive on a judge's final verdict of a crime and what transpired to incite that judgment. It was a quiet evening in April 1990 when David Lange, former Prime Minister of New Zealand, settled into his living room. He wasn't expecting drama. His prime ministership had ended just a year earlier, and while he remained a New Zealand MP until 1996, he was trying to enjoy a life away from the constant glare of public scrutiny. Then, on the television, a program appeared that would upend his calm. The ABC, Australia's national broadcaster, rebroadcast the majority of a program that had been run by Television New Zealand's Television One network entitled Frontline, suggesting Lange had acted improperly while in office. The accusations and insinuations were sharp, cutting deeper than any critique of policy ever could. Lange knew he had to respond. Thus began a legal battle that would captivate lawyers, journalists, and citizens alike. Lange sued the ABC for defamation. The statement of claim was issued in the New South Wales Supreme Court on the 14th of June 1991. It reads, "On Monday, 30 April 1990, by the program entitled Four Corners, broadcast on Channel 2 throughout each of the said states and territories, the defendant, the ABC, published of and concerning the plaintiff, the matter set out in its ordinary and natural meaning, conveyed the following imputations, each of which is defamatory of the plaintiff. That the plaintiff as Prime Minister permitted big business donors to dictate government policy that would not otherwise have been the policy. That the plaintiff was guilty of abuse of public office in that he attempted to arrange for a debt incurred by the New Zealand Labour Party at the 1987 New Zealand election campaign to be written off by the awarding of government contracts to the creditor. That the plaintiff was unfit to hold public office in that he regarded it as proper political conduct to permit a debt incurred by the New Zealand Labour Party at the 1987 New Zealand election campaign to be written off by the awarding of a government contract to the creditor. That the plaintiff was unfit to hold public office in that he regarded it as proper political conduct to consider allowing a debt incurred by the New Zealand Labour Party in the 1987 New Zealand election campaign to be written off by the awarding of a government contract to the creditor. That the plaintiff is a corrupt politician in that he accepted gifts of parcels of shares and profits on share trading transactions from Sir Frank Renouf in return for permitting Sir Frank Renouf to influence government policy in favour of big business interests. That the plaintiff acted deceitfully in that he permitted a share trading account to be established and conducted on his behalf by Sir Frank Renouf in return for permitting Sir Frank Renouf to influence government policy in favour of big business interests. That the plaintiff acted wrongly and that he allowed public assets to be sold off to New Zealand businessmen to repay them for their donation of election funds to the New Zealand Labour Party during the 1987 New Zealand election campaign. That the plaintiff disgraced the office of Prime Minister of New Zealand by skulking the streets of Auckland to attend secret nighttime meetings with board members of a state-owned enterprise. By reason of the said publication, the plaintiff has been gravely injured in his reputation and has suffered damage. The plaintiff claims damages, aggravated damages, and interest thereon pursuant to Section 94 of the Supreme Court Act of 1970. The statement of claim says on behalf of Mr. Lange, the plaintiff says that his damage is aggravated by reason of the following acts of the defendant. The defendant deliberately chose to broadcast the matter complained of, notwithstanding that it received a letter dated 30 April 1990 from the solicitors for the plaintiff stating inter alia that they had received instructions from the plaintiff in respect of a television program broadcast in New Zealand on the 29th of April 1990 on Television New Zealand's Television 1 network entitled Frontline, which was substantially similar to the defendant's own broadcast, and that the plaintiff considered the contents of the said television program grossly defamatory of him, and further, that the broadcast of the said program by the defendant would result in the issuing of proceedings by the plaintiff against the defendant for defamation, from which it is to be inferred that the defendant knew that the plaintiff disputed the facts contained in the matter complained of, but made no attempt to investigate their accuracy in light of his denials, and would not let the truth stand in the way of its determination to publish a scandalous and defamatory broadcast. That at the conclusion of the said broadcast, the defendant published the following words. And I should mention that Four Corners was contacted today by lawyers for David Lange asking us not to run the story, which they say is grossly defamatory. From which it is to be inferred that the defendant chose to use the plaintiff's urgent attempt to protect his reputation to further defame the plaintiff by emphasizing to viewers of the defamatory broadcast that they were aware of the plaintiff's complaints and chose to broadcast anyway. At first glance, it seemed like a straightforward fight over reputation. But beneath the surface there was a deeper struggle. The case would test the very boundaries of free political speech in Australia. In the courtrooms that followed, tensions rose, reputations were on the line. Not just personal reputations, but the reputations of governments. The New Zealand Prime Minister, who succeeded David Lange, Geoffrey Palmer, said of the episode of Four Corners, "The television program last night was the most dishonest, distorted, deceitful and disgraceful program that I have seen for a very long time. I am using those words very strongly and intentionally. This was a program that was not based on fact, it was based on a theory. They set out to go and find things to try and prove the theory. In fact, this program was based on a series of big lies." Lange's lawyers meticulously argued that the broadcast had been careless, misleading and damaging. The ABC's team, equally meticulous, countered that they had a duty to inform the public, especially about the actions of a former political leader. The ABC argued, in a democracy, citizens must be free to know and to discuss what their leaders have done. As the dispute climbed through the judicial system, the stakes grew higher. The defamation was initially heard in the Supreme Court of New South Wales. The defendant, the ABC, relied on what is called the Theophanous case and on the expanded duty interest form of qualified privilege. The plaintiff, Mr. Lange, moved to strike out the defences, alleging that they were bad in law. The matter was removed to the High Court, and by the time it reached the High Court in 1997, it was no longer just about one man's reputation. Coming up, the court case and the lasting impact it would have on the relationship between politicians and the media at large. The justices of the High Court were being asked to resolve a constitutional question that had never been clearly answered. Does Australia recognise an implied freedom of political communication? And if so, how does it coexist with defamation law? The actual High Court judgment reads, "The principal questions arising from this case are whether the court should reconsider two decisions which hold that there is implied in the Constitution a defence to the publication of defamatory matter relating to government and political matters, and, if so, whether those decisions are correct. Let's look first at what's called the Theophanous case. In 1992, Dr. Andrew Theophanous, a federal member of Parliament, sued the Herald and Weekly Times Limited, the publishers of the Sunday Herald Sun, for defamation. The newspaper published a letter by Bruce Ruxton, the then president of the Victorian branch of the Returned Services League, which accused Theophanous of favouring Greek migrants over other groups. Theophanous argued that these claims damaged his reputation and were false. In October 1994, the High Court of Australia ruled in part in favour of Theophanous. But the ruling was not a complete victory. The court upheld the implied freedom, but remitted the case for further consideration, meaning Theophanous did not necessarily win outright. The court found that the letter was defamatory and that the newspaper could not rely on the defence of qualified privilege, which is a legal protection for certain communications, because it hadn't taken reasonable steps to verify the information before publication. Importantly, the court also recognised an implied constitutional right to freedom of political communication. This means that discussions about government and political matters are protected under the Australian Constitution, but this protection doesn't automatically shield defamatory statements made in such contexts. The Theophanous case was significant because it was one of the first instances where the High Court acknowledged the implied freedom of political communication in the Australian Constitution. However, this implied freedom doesn't provide an absolute defence against defamation. It must be balanced with the protection of individuals' reputations. Theophanous established a broader defence for political communication, which was later refined in the Lange case. Theophanous initially suggested a more expansive protection for political speech, which Lange moderated by emphasising what was called reasonableness. The High Court also considered the 1994 decision in Stevens versus Western Australian newspapers. In that case, the High Court had held that a defamatory publication about a public figure could be defended if it was made in the course of discussing government or political matters, even if the publication was not reasonable or made with due care. This decision effectively constitutionalised defamation law by allowing a broader defence for publishers discussing political topics. The Stevens case was significant because it was one of the earlier decisions that expanded the scope of defamation defences based on the implied freedom of political communication. In Lange, the decision ultimately refined this approach, establishing a more balanced test that considers both the importance of political communication and the protection of individual reputations. The Lange case later clarified that reasonableness is a key requirement for the defence, effectively narrowing the Stevens approach. The Lange case refined and limited the broader protections suggested in the Stevens case. Returning to Lange versus the ABC. On one side, Lange's team represented the individual harmed by careless words. On the other, the ABC stood as the voice of the public, defending the principle that free discussion about political figures is essential to democracy. The High Court was presided over by Justices Brennan, Dawson, Toohey, Gaudron, McHugh, Gummow and Kirby. The judges listened, questioned and weighed arguments carefully, conscious that their decision would echo far beyond this case itself. When the High Court delivered its judgment, it reshaped the legal landscape. The court confirmed that Australia's Constitution contains an implied freedom of political communication. The court held that while the Constitution implies a freedom of political communication, this does not automatically provide a defence to defamation actions. Instead, the court extended the common law defence of qualified privilege to better align with the implied freedom of political communication. This means that publishers can defend defamation claims if the publication was made in the course of discussing government or political matters, provided the publication was reasonable in all the circumstances. Yet the 7-member High Court was careful to draw boundaries. This freedom was not a blank check. Media organisations could discuss politicians past and present, but their commentary had to be fair, reasonably accurate, and responsible. Speech could not recklessly harm reputation. For Lange, the broadcast's damage to his reputation was acknowledged, but the broader significance was monumental. Lange versus ABC set a clear precedent for how Australian courts would balance defamation and political speech. It gave journalists guidance, report and critique, yes, but do so responsibly. It reminded politicians and citizens alike that open debate is vital, but truth and fairness cannot be abandoned in the name of discussion. Imagine for a moment the public following the story. Newspapers dissected the judgment, commentators debated its implications, and law students across the country studied it as a case that would define their understanding of democracy and the Constitution. The decision didn't just resolve a dispute, it provided a roadmap for how Australians talk about their leaders, past and present. The case also clarified a confusing area of law. Prior to Lange, earlier decisions, like Theophanous versus the Herald and Weekly Times, had hinted that political communication deserved protections, but the limits were unclear. The Lange case gave clarity. Freedom exists, but it is intertwined with responsibility. The decision in Lange versus ABC had significant implications. It established the Lange test, a 2-step process for determining whether a law infringes upon the implied freedom of political communication. This test requires courts to assess whether a law burdens political communication and, if so, whether the law is justified in a democratic society. The case also clarified the relationship between defamation law and the implied freedom of political communication, ensuring that individuals' reputations are protected while allowing for open political discourse. Media outlets and citizens could discuss politics, but not at the expense of truth and personal dignity. Scene by scene, the story of Lange versus ABC is a tale of tension, principle, and balance. There is Lange, a former Prime Minister confronting a powerful media organisation. There is the courtroom, alive with argument and anticipation. There is the High Court, weighing the scales between free speech and individual reputation, knowing its decision will ripple for decades. For Lange, the personal victory was sweet, but he understood the broader impact. The judgment became a benchmark, a reference point for how Australia navigates the delicate balance between freedom of expression and protection of personal reputation. It reminded all Australians that democracy is not just about the loudest voice, but about fairness, responsibility, and accountability. Even today, the echoes of that 1997 decision are felt. Journalists, politicians, and citizens operate with a clearer understanding of what political communication can and cannot do. Lange's story is a testament to the power of the law to protect both the individual and the democratic process, a reminder that reputation and free speech can coexist, but only when guided by fairness and integrity. As listeners reflect on Lange versus ABC, the narrative comes full circle. It is a story of one man's fight for his good name, a media institution's duty to inform, and a high court that defined the rules for everyone. The case was sent back to lower courts to be resolved and was later settled in terms favourable to Mr. Lange. David Lange died, aged 63, in August 2005. Thanks for listening to Crime Insider's Judgments. We love hearing your feedback, so please rate and review this episode. If you have a case you want us to cover, let us know via Instagram at Listener Crime or TikTok at Listener Crime Team. I'll be back again next Thursday with another case. I'm Dan Mullins, with sound designed by Niall Fernandez. This series was recorded and produced on Gadigal land.